Senator from Utah.
I ask unanimous consent to suspend the quorum call.
Without objection.
Mr. President, I ask unanimous consent that there be 1 hour of debate on my amendment, number 2366, equally divided between the opponents and proponents, and that following the use or yielding back of that time, the Senate vote on the amendment.
Objection.
Mr. President.
Senator from South Carolina.
Reserving the right to object. Senator Lee is a very good friend. He's very sincere. I will object, and I want to just let the body know. I think the best way to handle this issue is if an American citizen is suspected of collaborating with the enemy, ISIS or Al-Qaeda, we have a due process in place to strip them of their citizenship, and that way you don't have the problem of reading their Miranda rights. You can hold them as an enemy combatant without question. And I just end with this. There's a court case right on point. Mr. Padilla was held as an enemy combatant, an American citizen, and the court said it doesn't matter the location of capture. You can be captured in the United States and still be held as an enemy combatant. So I object, and I really want to work with Senator Lee to see if we can find a compromise down the road.
Objection is heard.
Mr. President.
Senator from Utah.
Mr. President, I appreciate the opinions of my colleague, the senator from South Carolina. I would like to respond for a moment and speak for a few minutes about a bipartisan compromise that I've introduced along with the senior senator from California, Senator Feinstein. The legislation I'm referring to is called the Due Process Guarantee Act, and Senator Feinstein and I have introduced this as legislation, and it's also been offered up as an amendment to the legislation now before this body, to the National Defense Authorization Act. Alexander Hamilton, writing in Federalist 84, called arbitrary imprisonment one of the favorite and most formidable instruments of tyrants, and with good reason. The Constitution includes safeguards against this form of tyranny, including the right of habeas corpus and the guarantee that American citizens will not be deprived of life, liberty, or property by the government without due process of law. You're going to take away somebody's life or liberty or property, you've got to give them due process. You can't do it without that. That's by mandate of the Constitution. It's made clear as applicable to the federal government in the Fifth Amendment, and it's made applicable to the states through the 14th Amendment. Our commitment to these rights has, of course, been tested at times, in times of crisis. This is what happens to our rights when crises erupt. Now, sadly, tragically, I would add, we as Americans have not always passed these tests. We've not always emerged unscathed from the temptation to dip into the well of deprivation of due process in times of crisis. During the Second World War, for example, President Franklin Roosevelt unilaterally authorized the internment of over 100,000 Japanese Americans for fear that they would spy against the United States. 100,000 Americans, just based on the fear that they might spy against the United States. Now, to be sure, the government, neither President Roosevelt nor anyone in his administration presented any kind of evidence that these Americans, the 100,000 Americans who were imprisoned at that time, posed any kind of threat to our country. Not one piece of evidence, not one shred, not one scintilla of evidence was presented to that effect. In fact, most of these Americans were themselves native-born citizens, eligible in that respect to run for president of the United States. Many had never visited Japan in their entire lives. Many didn't speak the language spoken in Japan. Now, that episode in our nation's history was tragic. It remains a blight on our record to this very day. It's also an example that is sadly personal to the state I represent. You see, the U.S. government unjustly detained thousands of Japanese Americans in Utah at the Topaz War Relocation Center. Now, Japanese American internment is perhaps the most dramatic and shameful instance of this kind of detention in our nation's history. But unfortunately, it's not the only instance. In 1950, in a climate of intense fear about communist infiltration of the government, Congress enacted the McCarran Internal Security Act and did so over the veto of President Harry Truman. That law contained an emergency provision allowing the President of the United States to detain any person he thought might spy on the United States. Think for a minute about what that means. That one person was then vested with this authority to delve most deeply into someone's due process rights without providing them with any due process at all. That's scary. That's the very kind of thing that the Constitution was designed to protect against. The Due Process Clause, certainly, but the whole point of having a Constitution in the first place is to protect the people from the dangers inevitably presented by the excessive accumulation of power in the hands of the few. And then more recently, in the post-9/11 era, there has, of course, been some renewed pressure to diminish our constitutional protections, our liberty, in the name of security. Lawmakers from both parties have authorized the detention of Americans suspected of terrorism. Their detention without charge, without trial, indefinitely, and without meeting the evidentiary standard required for every other crime, potentially for the rest of their lives. You see, this happened just a few years ago in this very chamber. If I hadn't been here at the time, I might have accused whoever was describing this of engaging in some sort of paranoid fantasy, in some sort of odd hyperbole for the purpose of making a point. But no, this actually happened. In the National Defense Authorization Act that President Obama signed into law for fiscal year 2012, Congress authorized the indefinite military detention of suspected terrorists, including American citizens apprehended on U.S. soil. These episodes, the Japanese-American internment, the McCarran Internal Security Act, and the 2012 NDAA, are significant. They are teachable moments, if you will. In all three cases, the United States faced real threats from formidable foes, foes hostile to our very core values as a nation, foes who are not comfortable with the idea that we as Americans share in common, which is the belief in the fundamental inherent dignity of the human soul. But instead of defying our foes by holding fast to those core values, we jettisoned them in a panic. Fear and secrecy won out. The Constitution lost. Liberty lost. Thankfully, that's not the whole story. For there have also been times when Americans have stood up for the Constitution, even in the face of threats, especially in the face of threats, thus sending a really strong message to the totalitarian forces arrayed against us. For instance, in 1971, Congress passed the Non-Detention Act, stating that, quote, no citizen shall be imprisoned or otherwise detained by the United States except pursuant to an act of Congress, close quote. Now, Congress can make another stand for the Constitution by allowing a vote on this amendment, by allowing a vote on the Due Process Guarantee Act amendment to the NDAA. So what, you might ask, is the Due Process Guarantee Act? Well, in short, this bill presented as an amendment would raise the bar that the government has to clear in order to claim and assert the right indefinitely to detain American citizens and lawful permanent residents who are apprehended on U.S. soil. It would forbid the government from justifying such detentions using general authorizations of military force, such as the 2001 AUMF against the 9/11 plotters. Why, you might ask, would this even be necessary? Why would we even need to consider doing this? Well, that's a very good question, and that's a question that should be directed toward those who inserted this language into the 2012 NDAA. Under this legislation, under this amendment as it's been proposed, the government would have to obtain explicit written authorization, statutory authorization by Congress, the branch of government most accountable to the people at the most regular intervals, before approving the detention of Americans without charge, that is, if they're captured in the United States. This isn't too much to ask. Some would say this is far too little to ask. It is something that is required both by the letter and by the spirit of our Constitution, and by the very concept of liberty, and by the very concept alluded to earlier, that each human soul has inherent dignity that needs to be respected by our government. So the Due Process Guarantee Act is based on a very simple premise. If the government wants to take the extraordinary step of apprehending Americans on U.S. soil without charge or trial, it should get extraordinary permission from Congress. Now, to be very clear, if my colleagues want to grant the government this power, that power over their own constituents, their own voters, the very people who elected them into office, then by all means, let's have that debate, let's have that discussion. And if they want to do that, let them authorize it themselves. I hope never to see the day when that would happen, but I think we should all be able to agree that we should have to agree, the Congress should have to agree, before any such step is taken. Members of Congress should not simply hide behind vague, broad authorizations so that the voting public won't or can't know what they're doing. I'm offering this amendment because of my faith in our law enforcement officers and our judges who have successfully apprehended and prosecuted and overseen the prosecutions of hundreds of homegrown terrorists. Their example proves that our security is not dependent upon a supercharged government and a correspondingly weakened Constitution. We can secure the homeland without using the formidable instruments of tyrants. Not only can we, Mr. President, but we must. This, after all, is our constitutional imperative. Each one of us, upon taking office, was required to take an oath to uphold and protect and defend this document, the United States Constitution. And I would hope, I would think, I would expect, in fact, I'm quite confident, that the overwhelming majority of our constituents, of voters in every state in this country, regardless of where they fit on the political continuum, where they would identify themselves on the political spectrum, would agree that it's not really too much to ask to say that if the government's going to arrest someone and detain them, putting them into a position of incarceration indefinitely without charge, without trial, that's extraordinary. And that kind of extraordinary remedy perhaps ought never to be approached, but certainly if it's going to happen at all, it ought not ever happen without the explicit statutory authorization from Congress. All of this relates back to Section 1021 of the 2012 National Defense Authorization Act, which purports to authorize the government to indefinitely detain without trial American citizens and lawful permanent residents, both of whom would be protected by my amendment here, who were captured in the United States. So, look, it's easy to look at this. It's easy to separate yourself from this if you think this measure could apply only to bad people. Maybe only to bad people who don't look like people that we ordinarily associate with. Perhaps they don't look like they came from our neighborhood. Perhaps they don't look like the kinds of people who ought to have protections. But this, Mr. President, is the very folly that we should always seek to avoid. Either due process is a thing or it's not. Either due process is a constitutional imperative that we should be very, very reluctant to depart from ever, or it's not. Section 1021 of the 2012 NDAA represented a departure from that. Think of it this way. Your rights as an American citizen to be charged in a certain way, to have access to a speedy trial, to have access to counsel, your rights to a whole host of constitutional protections generally does not and ought not ever be something that should be dependent upon how you are charged. If all the government has to do is alter the way in which you were charged, to allege that you have been involved in some type of offense that can be characterized as terrorist activity or the aiding and abetting of those who planned the 9/11 attacks, if that's all that has to happen, then you're entrusting an enormous amount of discretionary power to government, to a very small handful of decision makers who themselves can deprive you of everything that's dear to you, of those you love, of the place you call home, and subject you to indefinite incarceration, indefinite detention, without access to trial, without access to the ability to confront your accusers in front of a jury of your peers. This is a problem. And it's a problem that would sound extreme if it weren't true, because it is, in fact, extreme. Now, we've gone now for the last 6 or 7 years after this was passed into law without it getting a whole lot of attention. I think this is unfortunate because this ought to be concerning to every single American. If you exist on U.S. soil lawfully, if you are a citizen or you are a lawful permanent resident, this should concern you. Even if you're not, even if you reside outside the United States or are here temporarily, perhaps on a temporary visa of some sort, this should worry you. If you believe in the American dream, if you believe in the fundamental dignity of the human soul, this should bother you. And the extent to which you're bothered by this should grow even more severe by virtue of the fact that we have this discussion this afternoon in our nation's capital, within the halls of what purports to be the world's greatest deliberative legislative body. Not in the context of being on the precipice of casting a vote on this. No, we're having this in the discussion of a simple request to vote, up or down, yes or no, yay or nay, on whether or not we should require Congress to state explicitly when it's going to invoke this kind of extraordinary remedy. It defies reason, it defies logic, it defies the rules, the customs, the traditions of this great legislative body for us to refuse to cast a vote on this. By the way, about 5 years ago, a nearly identical version of this same amendment passed through this body with 67 votes. Not only is that more than a majority, but it's also more than the standard required to close debate, and it's also a standard that is consistent with what's required to overcome a presidential veto. And yet somehow that measure didn't make it into the final product. Somehow it didn't survive the process of negotiation between the House and the Senate. It didn't survive the final bill as produced by the conference committee. And so 5 years go by. And we've been trying to get a vote on it ever since then. We have been unsuccessful in doing so. We're not asking for every member to agree right now to support this. What we are asking for is for them to weigh in and allow us to cast a vote on this. You see, we have this quaint idea in this country that being governed requires a certain amount of consent from those being governed. That when the government does something, especially something that could so deeply impact the lives of individual Americans, that it ought to be done with the consent of the governed through their elected senators and representatives. We've got 2 people here from every state in the union. I could say with a high degree of confidence, Mr. President, that if you polled not just the American people at large, not just people within every state, but I would add to that people within every demographic, people within every political party, at least every political party that I know anything about, people regardless of race, sex, national origin, religious affiliation, belief or unbelief. I would bet that an overwhelming majority of people in every single category, in every state in the Union, would say that this is really troubling. The fact that you would have a government that would be so bold in the first instance as to claim the right, which it did in the 2012 National Defense Authorization Act, to detain indefinitely citizens of this country apprehended on U.S. soil, without charge, without trial, without access to counsel, and that after having done that a few years ago, this same body would refuse even to allow a vote on whether future votes should be cast on whether or not this is appropriate. The Senate, I'm told, used to be a place, in fact, the history books make clear that it was, in fact, a place where extended debate and discussion could be heard. Because we, as a people, tend to believe that more debate is preferable to less. More input is preferable to less input. And that whenever governments make a decision, especially a profound decision like the one we're talking about here, that the people's elected representatives ought to have some say in it. It's an act of cowardice, Mr. President, that we as a body would refuse to cast votes on something like this. So I say to my colleagues who object to us even being able to cast a vote on this, what are you afraid of? What is it that you fear so much about the American people that you're unwilling to have a provision like this explored, examined, and yes, voted on by the United States Senate? This doesn't have to take a long time. We could have easily done it today. We could have done it in a matter of hours, perhaps a matter of minutes. But is that really too much of a sacrifice to ask for a few hours or a few minutes of our precious time to vote on whether or not the U.S. government should have the power indefinitely to detain, without trial, without charge, without counsel, American citizens apprehended on U.S. soil? I think not. And I'd implore my colleagues, with all the energy I'm capable of communicating, to please reconsider. Look in the mirror. Examine your conscience. You decide whether you want to stand accountable to God and the American people one day, if and when this power is abused. One thing we know about power is that when it's excessively accumulated in the hands of the few, bad things happen. Human beings are flawed. They're redeemable, but they're also flawed. That's why we have a Constitution. That's why we're here. We're here to cast votes and to stand accountable to the American people. I urge my colleagues to allow a vote on this amendment, Mr. President. I yield the floor.